OPR discipline usually starts with a referral. It can come from an IRS employee like an auditor who spots a preparer tied to an abusive shelter, or from a state licensing board, or even a criminal conviction. On the EA exam, remember, the trigger isn't just client work. Your own tax compliance can be misconduct too, like repeatedly filing late or not filing at all. Once OPR goes formal, it issues an official complaint. The complaint must name the respondent, lay out clear facts, be signed by the OPR director, and state the sanctions sought. If it's a suspension, the duration has to be stated. Exam tip: they love testing service methods. Email is not valid service for the complaint. Service has specific allowed methods: certified mail, first-class mail if certified is returned undelivered, private delivery service, in person, or leaving it at the practitioner's office. The complaint must give a response due date that's at least 30 days after service. And within 10 days after serving the complaint, OPR must also serve copies of the evidence against the practitioner. The response is not a vague denial. The practitioner must admit, deny, or state they lack enough information for each allegation. And you can't deny a material allegation you know is true. The brutal rule: if the practitioner doesn't respond on time, that failure is treated as an admission, and OPR can impose sanctions without a hearing. That's a favorite exam trap. If there is a response, the case goes to a hearing before an administrative law judge. Both sides can be represented: practitioner by an attorney or another practitioner, and OPR by an attorney or an IRS employee assigned to the case. For suspension or disbarment, OPR's burden is clear and convincing evidence that the practitioner willfully violated Circular 230. Willful is also exam language. It means a voluntary, intentional violation of a known legal duty. After the hearing ends, the ALJ must issue a decision within 180 days. If nobody appeals, that ALJ decision becomes final, but either side can appeal to the Treasury Appellate Authority within 30 days. On appeal, the Treasury Appellate Authority reviews briefs and issues the final agency decision. For OPR, that's the end of the line. The practitioner, though, can seek judicial review in U.S. District Court. The court doesn't redo the whole case. It will generally only set aside the decision if it's arbitrary or capricious, contrary to law, or an abuse of discretion. A Circular 230 practitioner must, when requested by OPR, provide OPR with any information they may have about a Circular 230 violation by any person, except in which circumstance. The choices include withdrawing from representation, privilege, doubtful legality, or a combination of privilege and doubtful legality. Think about it. What's the narrow exception rule here? The correct answer is the combination. The practitioner believes in good faith the information is privileged, and the request is of doubtful legality. Privilege alone is tempting, but the exam wants the full exception language: good faith, reasonable grounds, and the request being legally questionable. Withdrawing from representation doesn't erase the duty to respond to OPR. Which of the following is an offense that could lead to practitioner sanctions by OPR under Circular 230? The options are gross negligence, gross incompetence, gross delinquency, and gross recklessness. One of these is a recognized Circular 230 basis for discipline. Think about which phrase actually appears in the rules. The correct answer is gross incompetence. Circular 230 allows censure, suspension, or disbarment for incompetence and disreputable conduct, and gross incompetence is a recognized basis. Gross negligence sounds plausible, but it's not the specific labeled offense they're testing in this question.